today I am going to speak about the abrogation of Article 370 and its legal implications. On the 5th of August 2019, India removed Article 370 and Article 35A from its constitution, taking away the special status that Jammu and Kashmir had held for over 70 years and reorganizing it into two union territories without ever asking the people of that land for their consent. Pakistan's position is clear. This action was both unconstitutional under India's own laws and unlawful under international law because it altered the status of a disputed territory without the consent of its people. Firstly, let us look at the constitutional procedure. Article 370 in its original form could only be removed if the Constituent Assembly of Jammu and Kashmir recommended it. Since that assembly represented the people during the constitutional settlement, it was dissolved long ago without ever recommending repeal. Instead of respecting this, India used a presidential order in 2019 to reinterpret Article 367, simply replacing the words Constituent Assembly with Legislative Assembly. This was not a lawful shortcut, but a substitution of the very institution the Constitution had named as the sole authority for such a change. Once the Constituent Assembly ceased to exist, Article 370 could no longer be lawfully removed by any other means, which makes the entire abrogation invalid from the start. Secondly, consider the use of emergency powers. At the time, Jammu and Kashmir was under president's rule, so there was no elected government, and the Indian Parliament exercised powers that would normally belong to the state's own legislature. In effect, the Union government gave consent on behalf of the very state whose autonomy was being removed. President's rule is meant to be a temporary emergency measure, not a tool for permanent, irreversible constitutional change. Using it this way without any participation from elected representatives was an abuse of emergency power that denied the people of Jammu and Kashmir the democratic consent this decision required. Moreover, this was also a blow to federalism. Jammu and Kashmir was reorganized from a full state into two union territories. While Article 3 of the Indian Constitution allows Parliament to reorganize states, this power was never meant to permit the complete reduction of a state's constitutional standing without meaningful participation from its own population. Federalism is a core feature of India's constitutional structure, and this change was not simple administrative restructuring, but an unconstitutional alteration of the political identity and federal status of a disputed region. Furthermore, there were serious changes to land, employment, and identity. Before 2019, Article 35A let the Jammu and Kashmir legislature define permanent residents and protect their rights over land, employment, and education, preserving the region's economic and cultural identity. After the abrogation, new domicile rules widened who could claim residency and changed property ownership restrictions on a disputed territory whose demographic character India has no unilateral right to alter. Since residency and property rights are tied to identity and political representation, this touches the right to self-determination and is therefore a matter of international concern. In addition, international law speaks clearly on this matter. In 1948, the Kashmir dispute was brought before the UN Security Council. Resolution 47 recognized the dispute and called for its future to be decided through a process reflecting the wishes of its people, a position reaffirmed by Resolution 91 and Resolution 122 pending a plebiscite. By abrogating Article 370, India acted against this framework, preempting a decision reserved for the Kashmiri people and undermining a process both countries had earlier accepted. Under the Simla Agreement and the Lahore Declaration, India and Pakistan had further agreed to resolve Kashmir peacefully and bilaterally, not through unilateral measures. The abrogation broke both commitments. It also stands against Article 1 of the International Covenants on Civil and Political Rights and on Economic, Social, and Cultural Rights, which protect a people's right to determine their own political status. Finally, the prolonged restrictions on political activity and communication that followed raised serious concerns under international human rights law, which obliges states to protect political and civil rights, even within territory they claim as their own. After that, let us turn to the path forward. Pakistan's options lie mainly within international diplomatic and legal forums. Raising the issue at the UN Security Council and the UN Human Rights Council, and pursuing the International Court of Justice where jurisdiction allows, though these forums rely chiefly on investigation, reporting, and diplomatic pressure rather than direct enforcement. India argues that Article 370 was always temporary and that Parliament had the authority to remove it for the sake of equality and development. Yet even a temporary provision had to be removed through its own prescribed procedure, and Parliament's general power to reorganize states cannot justify removing constitutional safeguards without democratic participation. At last, let me conclude. The abrogation of Article 370 remains deeply contested, both constitutionally and internationally. The proper procedure was not followed, democratic consent was missing, federalism was disturbed, and international obligations on self-determination and disputed territories were affected. India's domestic authority cannot override the international legal principles that apply to Jammu and Kashmir. Its final status must be decided peacefully, in line with international law, and above all, according to the wishes of its own people. Article 370 was not reform, it was the unilateral removal of 7 decades of constitutional safeguards. A presidential order can never replace the lawful procedure the Constitution demands. No domestic order can replace the plebiscite promised to the people of Kashmir. A legal safeguard turned into a lasting grievance. The abrogation was and remains unlawful. The dispute is not resolved, it must be settled through international law, not domestic decree. The restrictions that followed remain proof of an illegitimate act. The future of Kashmir belongs to its people, not to unilateral decisions.
Pakistan Zindabad.
Kashmir Zindabad.